very good morning once again, everyone. For today's session, we have amongst us Dr. K.P. Kylasanatha Pillay, Senior Advocate, Supreme Court of India. Sir has expertise in practicing in service law, constitutional law, civil law, criminal law, land reforms, land acquisition laws, and so on. He started practicing in 1986 at District Court, Trivandrum, and shifted to Honorable High Court of Kerala in 1990, and then shifted to Supreme Court of India in 2005. Sir, in 2009, got designated as Senior Advocate by full court meeting held at High Court of Kerala. He functioned as Standing Counsel for Textile Corporation of India in Supreme Court, as Senior Counsel for State of Maharashtra, and Senior Counsel for Government of India in Supreme Court. He trained mediator of Mediation and Conciliation Project Committee, Supreme Court of India. Sir has served as former Vice Chairman Bar Council of Kerala, former Director, National Thermal Power Corporation Limited. He has been visiting faculty in National Judicial Academy, Bhopal, Indian Law Institute, New Delhi, Kerala Law Academy, and he has been part-time faculty in Government Law College, Calicut, Ernakulam, and the list again goes on. Sir also has several publications and guest lectures to his credit. Mr. Pillay holds special position as mentor of CG3, Connecting Governed, Governing and Governance, an intellectual and social service organization of judges, academicians, lawyers, and public men. We welcome you, sir. We are honored to have you with us. Over to you, sir.
Thank you. Am I visible and audible to all?
Yes, sir, you are audible.
Very warm good morning to all of you present here. Dr. T.R. Subramania, Dean of Law School Faculty, all members of the esteemed audience, participants. It is indeed a very rewarding moment to meet all of you on this virtual platform. I salute this great institution, CMR University, launched with the vision of Sri Chikka Muniappa Reddy, who was a person committed to the upliftment of the jetsams and flotsams of the society, ordinary people. And now a premier institution catering to the academic needs of science and technology has recorded its presence in the legal education sector also. I congratulate our Dean, Dr. Subramania T.R., and all the faculty members for making the flag of this great institution afloat. I wish it success to scale peaks of excellence in future days to come, years to come. My association with the state of Karnataka is very intimate and close. While practicing in Kerala before the High Court of Kerala, and subsequently we had a number of eminent personalities, judges from Karnataka, who were not merely judicial officers, judges, but people with statesman-like qualities. I remember with gratitude and veneration, Chief Justice V.S. Malimat, Chief Justice Banur Mat, Chief Justice H.L. Dattu, Chief Justice Shandana Gowda, Chief Justice Her Ladyship Manjula Chelu. The state has had very intimate intellectual relations with our bar, our academia, and our society. So it makes me all the more happy, comfortable, and feeling at home while addressing you on this occasion. You are all academicians, learned. It is as a part of the faculty development program, thus that this lecture series is organized. I hope you have had a brilliant time during the last few days while attending sessions on various topics engaged by men of parts and parcel, erudition and scholarship. We have, when I discussed with our dean regarding the topic to be selected, I know that most of the topics selected for discussion would be specific topics on specific areas. Therefore, I suggested that I will rather discuss with you a topic comprehensive enough to comprehend two major aspects of our jurisprudence. Core competency of Indian judicial process, maintenance of rule of law, or administration of justice. It is a question. What is the core competency? You know, this expression is borrowed from the parlance of management studies. Now it is a part of our general academic parlance. The core competency of Indian judicial process, whether it is maintenance of rule of law or it is administration of justice. I may share my thoughts with you for the next few minutes on this apparently large or big topic, but we will try to find out some syllables pertaining to this topic and discuss it. Judicial process, as all of you know, it is a very or all-encompassing process, including administration of justice, maintenance of rule of law, keeping unity of society, respecting worth of man, and a plethora of other aspects. It is a stream. Judicial process is a stream like river Ganges or river Kaveri. It is polluted also at times. And attempts at purification also is there. For our limited purpose and limited time, we will be focusing on the post the constitutional period, post 1950 period. Because if we tread backwards, we have an uninterrupted recorded history of about 5,000 years, starting with the Vedas. And even a cursory glimpse into those areas will consume time. and it requires more better or more erudite scholarship than mine. So, with your permission, I will make a few observations on this topic. Core competency of judicial process in India, whether it is maintenance of rule of law or it is administration of justice. Both are not separable, I will tell you in the beginning itself. Both are two dimensions of a multi-dimensional process, maintenance of rule of law and administration of justice. There is a theoretical part to this rule of law concept. Rule of law is a concept and justice is an ideal, which we strive to. The theoretical part of, philosophic part of rule of law, all of you are aware, thanks to A.V. Dicey and his exposition of the principle of rule of law. But the practical, we are more concerned with the practical, pragmatic dimension of rule of law and how our judicial process takes care of it. When we say our judicial process, who are the stakeholders there? The courts are there, starting from Supreme Court or starting from the officials. Let us start from the beginning. The trial courts, subordinate courts, official courts, district courts, sessions courts, high courts, and Supreme Court, like a pyramid. And the judicial process juxtaposed to legislative process, administrative process, has got its own unique characteristics. It is the judicial process headed by, piloted by the apex court, the Supreme Court. Therefore, we are all concerned which way the Supreme Court, which direction Supreme Court thinks, acts, performs. If the Supreme Court catches cold, the entire judicial process judicially will cease. We speak about decentralization, we speak about separation, but the fact remains that the Supreme Court of India is the tune setter, trend setter, path breaker, path maker of rule of law. And now we have to examine with certain examples whether rule of law is maintained by the dictates of the Supreme Court judiciary, judicial process, or by the interventions of the legislature, or by the interactions of the executive. Let me start with a premise, a hypothesis, that it is the Supreme Court that calls the shot in maintenance of rule of law. First point, why I make this hypothesis, because in all common law countries, as you know, judiciary has got an upper hand. Even though the institution and the judges are under law, under constitution. We have the famous opinion of Chief Justice Marshall in Marbury versus Madison. We are bound by the constitution, but what constitution is, we will say. This is an emphatically asserting the position of judiciary as first among equals. What is law? So rule of law law that is to be ruled will be decided by, delineated by, exposed by, laid down by us, by the court. When Indian Supreme Court was inaugurated on 28th of January 1950, with the judges of the former federal court taking oath again as judges of the Supreme Court in the Royal Chamber of Parliament House. It did not have a building of its own. The first inaugural session was the presence of Prime Minister Pandit Jawaharlal Nehru, Deputy Prime Minister Sardar Vallabhbhai Patel, Chakravarti Rajagopalachari. So many stalwarts were there, statesmen. And Nehru, Pandit Nehru specifically said that I don't expect judiciary to do much other than interpretation of laws and adjudication of the lists coming before them. With an elected government, judiciary's role is limited. This was the view of Pandit Jawaharlal Nehru. Because we are legislature, we will decide what is law. We legislate. The judges of the Supreme Court, perhaps, they did not react. They just might have smiled, I don't know. Sardar Patel also reflected the same. And you know, it is history, what happened thereafter. In the United States of America, there is a continuous campaign against judges and especially Supreme Court under the banner of the concept of counter-majoritarianism. What is counter-majoritarianism? See, some 10 people, 9 in the United States of America, 33 in India. They are appointed people. They are not elected. They don't represent public opinion. They don't represent the opinion of the people. They are appointed in whatever clear, clean method. So they cannot usurp the majoritarian mandate enjoyed by the government. Alexei Bickel's book, I think most of you might have referred to it, The Least Dangerous Branch, about judiciary. And Alexei Bickel says that he criticized this counter-majoritarianism. So what happened in America happened in India in a greater, better, wider dimension. Years, decades subsequent to 1950, inauguration of Supreme Court, witnessed a scenario where Supreme Court, judiciary headed by Supreme Court, gradually overtaking other institutions. For brevity's sake, for clarity's sake, since I told you in the beginning itself that it's a very vast topic we have selected. Just to illustrate that it is the Supreme Court that decides, or I will ask a question and answer that. Who is the custodian of the Constitution of India? When Constitution was drafted and implemented and enacted by the people of India in 1949, November 26, and 1950 with the Republic, we thought that the custodian of the Constitution, generally we say people are the custodian of the Constitution. That is a different thing. That is for ornamental sake, for self-satisfaction sake only. Parliament was supposed to be the custodian of the Constitution. I will place before you 4 words, which will indicate 4 stages where the Supreme Court transformed into an institution, all-powerful institution, just like Alexander Selkirk in William Cooper's poem, My Rights There Is None to Dispute. I am monarch of all I survey. My rights there is none to dispute. So this, how Supreme Court emerged to this position? Number 1, a stage of competition. Number 2, a stage of confrontation. Number 3, a stage of confiscation. Number 4, a stage of consolidation. Now we are experiencing the stage of consolidation. Competition started in 1950 with Nehru's utterance. We can take it for granted. And within 1 week, A.K. Gopalan came to Supreme Court with a petition that there is only change of masters, no change of quality, no change of quality. And Supreme Court was faced with situation reaction tests every day, every sitting. Even though A.K. Gopalan lost the case, jurisprudence won the case. We had a discussion thanks to the forensic abilities of the father of present Attorney General, Barrister M.K. Nambiar, father of present Attorney General, Shri K.K. Venugopal, exposed the requirement of judicial intervention against administrative excesses, executive excesses. And this period of competition, you see, we have cases like Sajan Singh case, Isaac Golaknath case. Up to Golaknath, we can say that it was competition. With Golaknath, you know, Supreme Court established a definite benchmark for amendment of the Constitution, which was the bone of contention. When we discuss about rule of law, maintenance of rule of law, taking Constitution as the book of law, basic rule book, interpretation of the Constitution, amendment to the Constitution, interpretation of the amendments to the Constitution, they all go to add value to the concept of rule of law, maintenance of rule of law. So this competition, in the competition, even though it was a neck and neck race, the final kiss on the ever-rolling trophy of hegemony was done by judiciary with the IC Golaknath. Then there started the second stage of confrontation. Second stage of confrontation where matters reached, as you know, the mother of all cases, constitutional law cases in India. For the first time, 13 judges of the Supreme Court sat for about 70 days to hear the extra version of constitutional law, Indian history, social relevance, to decide Keshavananda Bharati versus State of Kerala and other cases. So confrontation. So a definite milestone was reached. Then this confrontation, it had its own repercussions, fallouts. You know, the political leadership of the day was headed by Srimati Indira Gandhi, a ruler not likely to take it very lightly, whether it is judicial intervention or anybody's intervention. We know that afterwards, national emergency was declared. judiciary with this confrontation, successful confrontation, was keeping a low profile during emergency. Not only a low profile, it had to face criticism also, as you know, in ADM Jabalpur versus Shivakant Shukla. The court held that citizens do not have a fundamental right to approach with habeas corpus petition to the high courts. Or in effect, the court held that when a national emergency is declared, the emergency is the rule of law, with the solitary exception of dissent of Justice H.R. Khanna. And Justice H.R. Khanna recollected the case of Liverpool versus Anderson in 1943, decided by the Court of Appeal in England. A similar situation where instead of a person like Justice H.R. Khanna, Justice Lord Atkin dissented, said that personal liberty is to be valued much more than security, because under the cover of security, you can thwart the personal liberty of a person, several persons. And the famous sentence of expression of Justice Atkin, I view with apprehension the attitude of some of the judges who are more executive minded than the executive. In India also, there were judges who were more executive minded than the executive in 1976 when ADM Jabalpur was decided. And immediately after emergency, Supreme Court got an opportunity to salvage its lost face through Maneka Gandhi's decision. All of you are aware of the contours of Maneka Gandhi's judgment. You might have been teaching it, referring it. You might have been reading and rereading Maneka Gandhi's decision, which we can say that the court got free from all shackles through Maneka Gandhi's decision. The court became independent. If Indians became independent in 1947 or 1950, the Supreme Court was laboring under competition, confrontation, and with Maneka Gandhi's decision, that is reflected in Minerva Mill's decision in 1980 also. So the court decides who will rule, what is law, what is rule of law, what law is to be ruled, implemented, enforced. That position is reached. So competition, confrontation. Now comes power corrupts, absolute power, absolutely. Lord Acton's famous sentence. Another proverb, another sentence. It is one thing to have the power of a giant and another thing to use it like a giant. And you have successfully completed competition, successfully completed confrontation, and now you come to confiscation. By confiscation, I refer to the judges' cases. The first judges' cases of 1982, High Court judges transfer case. Then the second judges' cases of 1992, Supreme Court Advocates on Records Association versus the Union of India. Third judges' case of 1998 in rare reference to by the President of India. Then the fourth judges' case of 1913, Supreme Court of Advocates on Records Association versus Union of India. What the court did is confiscating the power, confiscating the essence, spirit of rule of law. The court, through the collegium system, we the people of India, having solemnly resolved to constitute ourselves into a sovereign, socialist, secular, democratic republic. In 92, the Supreme Court of India said that we, the Supreme Court judges, are now hereafter making it ourselves to appoint our own people. Probably the only phenomenon in the world, the common law countries, where judges appoint judges. Where is the constitution? Wherein the Constitution is prescribed. What is the basic constitutional basis of, except Article 141 of the Constitution, that what we say is law. We are bound by the Constitution, but we are subjected to what law we will declare. So this collegium system has sealed certain things for our, and Supreme Court's supremacy is established, illustrated. This is not without a struggle. As far as Kylasanatha case is concerned, there is a small book by a scholar, Supreme Court in Quest of Identity, that is written against the background of Kylasanatha case by Gobind Das. Supreme Court in Quest of Identity. About Kylasanatha, there came a comment from Professor Austin also. Professor Austin has maintained that Kylasanatha case was decided, has been described as a poisonous decision. Poisonous decision. See, there is a very small book by former Attorney Solicitor General T.R. Andyarjuna. I recommend all of you to read, being academicians, to know what happened with I believe that many of you might have already gone through that book. T.R. Kylasanatha case, the untold story of struggle for supremacy by Supreme Court. So this supremacy was established not on a fine day. See, among the 13 judges, 11 judges wrote judgments. 11 judgments. And the background activities were so political, and Austin says that it was a political judgment, not a jurisprudential judgment. So my submission is that Supreme Court has established the authority to dictate law, and therefore the management, administration, or maintenance of rule of law is now on the basis of the thoughts, thinking, philosophy of the Supreme Court of India. With this, there was a feeble attempt to challenge the Supreme Court's authority to appoint judges. In 2013, when a proposal was made for National Judicial Appointments Committee legislations, then comes the fourth judge's case. A constitution bench headed by Justice Kahar dismissed all the, struck down these provisions and restored the original position, consolidated its power, consolidated all aspects of interpretation of the Constitution. Therefore, my submission before you, I am verifying it with the hypothesis which I made in the beginning, that the custodian of the Constitution is not the Parliament, not the people, not the executive. It is the Supreme Court of India. Since the custodian of the Constitution is Supreme Court of India, we can say that the rule of law, the elements of rule of law, the alphabets of rule of law, the syllables of rule of law, the mechanism, dynamism of rule of law are all decided by the decisions of the Supreme Court. And the Supreme Court rules the roost today in this consolidated position. And we know that government, even if it is a strong government run by a strong person, leader with absolute majority, even to amend the Constitution, today with the case laws behind us, with the ambience of jurisprudence around us, we can very well say that Supreme Court is the author, Supreme Court He is the executor. Supreme Court is the source of rule of law and maintenance of rule of law. This we can see from the huge volume of constitutional law that we have, what we call constitutional law. I have had a chance to read with profit Senior Nariman's autobiography before the memory fades. If among you those who have not read it, I recommend it because it is not a biography of Mr. Nariman. It is a biography of the Indian judicial process. It is a biography of Indian judiciary, especially Supreme Court. He starts from 1950, right from the inauguration of the Republic. Nariman takes us to the various incidents, coincidences, phases, stages, events, occasions of the Indian judiciary, especially Supreme Court, having its good times, bad times, and how it has weathered all storms to stand head and shoulders above all other institutions of the Constitution, under the Constitution. But there are problems. Problems are plenty because such an institution, is it giving full credit to the Constitution? Has the Supreme Court been successful in interpreting law to the requirement of 137 plus crore people? And Nariman says in 1950, what was meant by constitutional law of India? The constitutional law in India was the provisions of the Constitution, simply. But what is constitutional law today? In 2022, constitutional law includes the provisions of the Constitution. It includes the judgments of the Supreme Court interpreting various provisions of the Constitution. It includes the amendments to the Constitution, about 120 amendments proposed. It is a body of law. It is a gigantic body of law, which we call constitutional law, which the Supreme Court controls, rules, directs in the matter of maintenance of rule of law. I hope I have made some points on this first topic, first part of our discussion. And I pause here for a moment for suggestions, for observations, queries from among you before we start with the second limb of our discussion, today's discussion. Or shall we reserve this to the end of our discussion?
So we'll take it at the end of the session. You can continue further, right?
Okay, very good.
Yeah.
Now, I think I have made a case for the Supreme Court to be the sure candidate winning in the race of maintenance of rule of law. What I have discussed during these 30 minutes, let us test it against the situations faced by the Supreme Court. In the journals section of AIR 1925, page 1, journal page 1. There is an article on judicial discretion. Judicial discretion and administrative discretion. Both are different, even though discretion. We call the word discretion. In this article, one sentence I remember even today, though I referred to this article while doing my LLM. some 30 years back. Justice with the court is like a deposit in the Bank of England, as safe as a deposit in the Bank of England. It is Bank of England because in 1925 there was no Reserve Bank of India or Imperial Bank of India. This is the concept of justice. We have had philosophic utterances, oracular utterances of philosophers. Justice is the chiefest interest of man on earth. Roscoe Pound. Justice is probably sense of justice, urge for justice, wish for justice is the primordial character, nature of all human beings. Whether Indian judicial process has been successful in the administration of justice, whether the court has, the judicial institutions have been successful or had risen to the occasion in meeting with the needs of justice of the people. You know, I don't know whether I am fully correct, but I speak on the basis of information. Among the 137 crores of Indian citizens, there are crores and crores of people who do not know that such a thing as constitution is there in India. Such an institution as Supreme Court is there. It will be very surprising to make this observation. But the reality, in jurisprudence you study a lot of philosophies, theories, analytical legal positivism, historical theory, Scandinavian realism, then American realism. Let us have an Indian realism. Whether we have been successful in taking the message of justice, liberty, freedom to the last man, the man on the Kappa omnibus in the English type, the man in the street. That is where we have to start. And again, I adopt a tool of research or academics. I take a hypothesis. The hypothesis is that our judicial process has failed to rise to the occasion of administration of justice completely. Not completely failed, it has not achieved perfection. There is no consummation in the art of administration of justice as far as Indian judicial process is concerned. In 2000 AD, when Golden Jubilee was celebrated by our Republic, an anthology was published by the Supreme Court Advocates Association and others under the name Supreme, not Infallible. Supreme, not Infallible. That book is available in the market. It is an anthology collection of well-written articles by academicians, scholars, and others. Whether it was percolated in Supreme, not Infallible. Supreme Court is supreme. That we have demonstrated now, that we have seen now. It is supreme. But is it infallible? It goes wrong, whether it goes wrong. Whether Supreme Court has risen to the occasion. Already I have given you an example. During emergency, what the Supreme Court could do. Supreme Court could not do anything because Supreme Court had to dance to the tunes of the executive. And even the 42nd Amendment subsequently was repealed in piecemeal repealing. And there was even talk of a committed judiciary. So, in the 50s and 60s, what was the agenda of Supreme Court? The agenda of the Supreme Court was the problems of the rich, the problems of the landlords, the problems of the capitalists. It was life of law for Supreme Court then was logic. Oliver Wendell Holmes said, as you know, life of law is not logic, it is experience. So in the 50s and 60s, the judges remained in the ivory towers and they were aloof and away from the social, political realities. And administration of justice was what we called, it was in a limited way, justice according to law. See, when you speak about law, rule of law, justice according to law, you are speaking like a post-Christian bread, using a pro-Christian bread. But that should not be. You have to look around. You have to see for possibilities, other possibilities. Justice not to people who come to court alone. Justice to people who live normal life as citizens. In the initial 2 decades, Supreme Court was competing with the legislature, with the executive. Supreme Court was trying to find its own ground firm. And it reached the pinnacle at the time of emergency. You know, there is only one profession that is mentioned in the Constitution. Doctor's profession is not mentioned there. Engineer's profession is not mentioned there. Chartered accountants, they are not mentioned there. Only lawyer's profession. Which article? Which is the article which speaks about lawyers' counsel's profession? Article 22. Every person has a fundamental right to choose his counsel. You don't have a fundamental right to choose a doctor or an engineer. So this being the position, during emergency became the law. And personal liberties were given a go-by. The equation usually maintained in Article 19 of the Constitution was disturbed terribly. What is the equation maintained? You know. Article 19, 1, A to G specifies freedoms, and 2 to 6 specifies reasonable restriction. Reasonable restriction. Justice is reasonable, it should be reasonable according to the standards of interpretation of Article 21 of the Constitution. Reasonableness cannot be the wayward reasonableness of a Don Quixote like a person. And during this period, we had tasted the absence of rule of law, the caprices of rulers, executive tyranny, administrative excesses, compulsory sterilization of people, citizens, demolition of slums, dwelling places, putting behind bars free thinkers. I'm not talking on political lines, on legal lines, on the requirement of justice lines. And that phase was over. And a student of Delhi University, who was also a model for DCM textile group, known as Manega. Her passport was impounded by the government, and she happened to be the wife of a prominent politician of the day. And she approached the Supreme Court under Article 32 of the Constitution with a petition challenging the impounding of her passport. Especially thanks to Justice Bhagavati's responses. We have the Supreme Court confessing, Supreme Court admitting that our main function is to administer justice, even though Manega lost the case. See, in all important cases, the petitioners lose the cases. A.K. Gopalan lost the case, Kylasanatha Bharati even lost the case, Manega lost the case. But our jurisprudence has gained something because of the loud thinking of from the bench. And then comes the second stage of, I clubbed the first two stages of this competition and confrontation together. Then comes the stage of confiscation. I told you that Supreme Court has confiscated the essence and spirit of law, rule of law. And now I will tell you what happened after the post-emergency period or post-Manega period, or in the 80s. We have, as all of you know, social action litigation or public interest litigation, where the Supreme Court has opened all its doors, all windows, and fresh air started coming in. And we have a court for the people, a democratic court, where administration of justice has been its main theme or agenda. With public interest litigation, the forms of action, all basic principles like locus standi, form of petitions, all those things have been discarded. As you know, even a letter addressed to the Chief Justice of India was converted into a writ petition. Notice was issued to the authorities. It is not adversarial litigation. It is social action litigation, Supreme Court said, regarding bonded laborers, rural people, prisoners, widows, women and children, from various sections of the society. Topics like environment, topics like development, engaged the attention of the judiciary, and we have a plethora of decisions, catena of decisions dealing with these topics. When Asiad workers, Asiad, I don't know what was your age then, most of you, in 1972 when Asiad was staged in India, Delhi. Asiad workers case, one of the first public interest litigations where they were given inadequate wages. Then Bendua Mukti Morcha case, Olga Telly's case, even prisoners' case. See, Charles Shobaraj versus Tihar Jail authorities. This is V.R. Krishnaiyer said, a prisoner is not does not shed his rights at the prison gate. He is a guest of honor of the government in the prison. He has got certain irreducible fundamental rights. In the area of protection of environment, in the area of all conceivable areas, Supreme Court had its impact. At the same time, there were in the over-enthusiasm to administer justice, Supreme Court had overstepped certain areas also. And that also it has invited criticism also. And in the process of which the Supreme Court has developed some doctrines also. Contribution to jurisprudence, like basic structure theory, like intergenerational equity theory, so many other polluter police theory. And we know that today there is not a single subject which is not touched by the Supreme Court of India. Once Veda Vyas composed Mahabharata, he said that he made a observation. You may find things discussed in this elsewhere, but you may not find things not discussed here elsewhere. Like that, Supreme Court has achieved a rare achievement in coming to the rescue of people of India in the matter of administration of justice. I have been stating very generally on this. Therefore, I will place before you some of the areas and some of the judgments for your notice. See, one area where Supreme Court has ended in the matter of administration of justice is transgender subject, topic of transgender. Not only Supreme Court, various high courts have come forward dealing with the topic of rights of protection of safety and security of transgenders. The Madras High Court had Sushma and Seema Agarwal versus Commissioner of Police. I am not going to give you the names and citations of all those cases. I know that you have resourcefulness enough to find out these cases. My humble endeavor is to suggest that these areas are areas where the Supreme Court has made its impact. Sexual rights, sexual discrimination rights, sexual protection rights, transgender, the matter of transgenders, the question of abortion, and conceding right to abortion. You might have read, I think at least many of you might have read the judgment of the American Supreme Court, which was delivered a month back, prohibiting abortion, reversing an earlier decision. The Supreme Court of India has come forward with like decisions that abortion can be permitted even beyond 20 weeks, subject to the requirement of the health of the mother. Then we have the question of environmental justice. Environmental justice, starting with the Rural Litigation and Entitlement Kendra, 1985. Starting from this decision, today with the tiger reserve, the protection of the tiger reserves of Nilgiris, the Supreme Court has been, as you know, Supreme Court in the way has developed certain ingenious mechanisms also. Most of you might have come across the decision of Godavarman Tirumulpad versus Union of India. state of Kerala. Godavarman Tirumulpad is a classic decision where environmental justice is administered by the Supreme Court. And Supreme Court devised a system of continuing mandamus in this decision. And Godavarman Tirumulpad was hanging fires for about 20 years in the benches of Supreme Court. People start filing petitions after petitions for environmental disputes, for various problems emanating from the violation of environmental safety. And the work done by public spirited lawyers like MC Mehta. In the name of MC Mehta, there will be a dozen important cases where he has taken up cudgel against the authorities and corporate people. The Supreme Court has been aiding, Supreme Court has been supporting, Supreme Court has been articulating the needs of justice in all this. I remember once in a river Ganga pollution case filed by MC Mehta, some projects were also opposite parties. Their factories were closed down. Corporate clients come with the most corporate-like lawyers in the Supreme Court. They have no dearth of money. The public interest litigation lawyer will be an ordinary lawyer. The other section will, whether it is Ambani, Adani, or Tatas, the corporates. I'm not naming so many, but corporates, among the corporates. And on one occasion, they came for vacating an interim order granted in favor of MC Mehta. MC Mehta also came prepared. He was a solitary reaper. He was a solitary fighter. On the other side, there was a battery of lawyers. All the high-paid lawyers available in the Supreme Court, engaged by these corporate entities. Then they filed an application for vacating the interim order. The judges asked MC Mehta, what is your reply to this? Say, they have made a case. This stay order is issued in their absence. Their business is being throttled. Mr. Mehta, what is your answer not to vacate this interim order? Then Mr. Mehta, MC Mehta, took a small bottle from his coat pocket and displayed it before the judges. This is water collected from river Ganga. If my learned friends on the other side can drink this water, I will withdraw my petition. If the lawyers who argued vehemently against me, if they can drink this water from Ganga, I will withdraw this petition and you can inflict any cost on me. Nobody was willing to drink that water. And Supreme Court said that we are not going to vacate the interim orders. This is the sense of justice shown by the Supreme Court. But at times, Supreme Court oversteps, I said. In the matter of religion, religion is a very sensitive, even in democracy, even in rule of law, religion is a very sensitive subject which must be dealt with very cautiously, very, what you call, must be very carefully dealt with. You can get applauses from one section, but you have to be ready to get the brickbats from the other section also. One case I will refer here. Supreme Court, in its over-anxiety, over-enthusiasm in the religious matter. Shabarimala case, I hope most of you might have heard of it. The litigation in which I also had a small part to play. The Supreme Court thought that the court would get applauses. I am not now arguing before you the issue of Shabarimala case, but the manner in which the Supreme Court dealt with that case and the judgment was delivered, and the manner in which the government misunderstood the capacity of the Supreme Court to keep it tight, and the people's response to it, that belied the expectation. And what happened thereafter? For the first time in the history of Supreme Court, about 80 review petitions were filed against a judgment. Largest number of review petitions against a judgment. And there was a request, usually, administration of justice, Supreme Court does not list and post the review petitions in the open court. The judges will sit in their chamber and dismiss it. If they issue notice, then thereafter it will be listed. But the Supreme Court, different judges coming thereafter, they listed it in the Supreme Court or open court. Thereafter it was referred to 7 judges bench. Thereafter to 9 judges bench. Now the case is having a Rip Van Winkle sweep in the registry of the Supreme Court. Not heard of for the last 3 years. So, administration of justice, you have power, you have giant's power, but don't use it like a giant. In the micro, macro, mega levels, administration of justice requires different approaches, different parameters. But we can trust that the Supreme Court will be able to rise to the occasion in the years to come. So, my submission with respect to administration of justice by the judicial process, where do we get justice? More from the executive or parliament, or from the judicial process. If you are the ultimate, the last word on justice is with the Supreme Court or with the executive. It was, belief was that it was with the executive, the president. Till the scope of judicial review was extended further to include the decision-making power of the President of India while disposing a pardon petition. While disposing the decisions of pardon by the President of India was supposed to be the final till 10 years back. Now with Perarivalan and others making inroads into the administration of justice sector, even that has been subjected to judicial review. So judicial review has been a weapon or a means for dispensation of justice. And in a common law country like India, like England, like America, administration of justice by the courts of law through judicial review, through the means of judicial review, has been a success story. R versus Prime Minister, 2019, a decision by the British UK Supreme Court. The context of the Brexit exit. The Parliament was prorogued, and the Queen passed the order, the advice by the Prime Minister to prorogue the Parliament was signed by the Queen, Her Majesty. Once Her Majesty signs a rule, order, that is final in England, and the British Supreme Court was headed by a lady Chief Justice. Somebody filed a petition before the lower court, then an appeal came, Miller versus Prime Minister, R versus Prime Minister. And the judgment begins with the observation that this is a rare case, such cases very rarely come. And we hope that such cases do not come before us. And the court quashed the order of prorogation and asked the Parliament to convene. See, this is the supreme success of a judicial institution to dispense with or administer justice. Such situations Indian Supreme Court had examined and experimented with earlier. And we have the case of Karnataka in our own state, Karnataka Assembly, this vote of confidence. Earlier in northeastern states, several states, Kikoto-Kolohan's case is the first Supreme Court judgment. So five judges made judgment. Therefore, my submission is that you being academics, every teacher, I also had a small experience in teaching in several institutions. And my professor used to tell that every teacher is an institution. So this this topic of core competency of Indian judicial process, maintenance of rule of law or administration of justice. Tomorrow, if when you deal with the topics under administrative law, constitutional law, criminal law, jurisprudence, if you might have found attractive any of my submissions, I will be all the more grateful to that. With one last point, which is outside the topic which we have selected, I will try to conclude my submissions. In another university, I went for a lecture, and the topic selected was black holes in Indian legal education. Black holes is in physics, I think. How black holes in Indian legal education? There are gaps to be filled. Our academy and our profession, our judicial process is yet to come to terms with the academic brilliance or academic identity of Indian academia. What is Article 124.3? 124.3 subclause 3. 124.3 subclause 3. Subclause C. A person shall not be qualified for appointment as a judge of the Supreme Court unless he is a citizen of India. And A, I leave it. B, has been 10 years standing, I leave it. C, is in the opinion of the president a distinguished jurist. We are celebrating our 75th year of independence. Our constitution has outlived several drastic amendments. Our judiciary has been successful and has become the custodian of the constitution. We never hear a debate on this, appointing a distinguished jurist as a judge of the Supreme Court. Does it mean that India has not produced any jurists? Does it mean that compared with the qualities and competence of the judges who occupy the benches today, our jurists or our members of the academics are lacking? Anyway, let us leave it to public debate. Let us leave it to the good sense of the collegium people for considering it. Whether this is to be a dead letter as it remained for the last 75 years. There is no meeting point between the academic area and the professional area. That is my submission. Whereas in all other common law countries, there is no distinction between these two areas, academics and professionals. Professionals are drawn from academic sector. Academicians are drawn from professional sections also. When American Supreme Court closes for vacation, judges would have already taken decision to visit which all law schools for interacting with students, for taking classes. I don't know what our judges do during vacations. Anyway, we hope that we have brilliant academic judges, judges like Justice Chandrachud, Justice Sikri, Justice Nageshwar Rao, several other judges, number of judges who are academically very brilliant. Only thing is that there must be a debate on this. There must be a debate. We must build channels of interaction. So with these few words, with your permission, I may conclude my words. I hope I have not bored you to an extent. And given an opportunity, I would love to visit this university physically. I have gone through the website and I have contacted others who are knowing this university and its functioning. You have a brilliant record. I find that you have good leadership under Dr. Subramania Saab, and let the law school also flourish like other branches of this university, science and technology. So now we can interact. If you think so, I leave it to you. Thank you.
Thank you so much, sir, for giving us insights in Indian judicial process and explaining us upholding of rule of law and justice. I am sure that all your inputs will help us to inculcate all these things in our sessions for teaching our students. Thank you once again for your enriching session. I request all the participants, in case if you have any questions, to please put up the question in chat box, or anybody from here.
You are not much audible. That's a... Do you have a microphone?
Yeah, they have.
Sir, actually, I wanted to know your insight regarding a matter. Last month, on July 27, Supreme Court passed a verdict on ED's power on PMLA Act. So do you think whether it is in conformity with the rule of law? And yesterday, Supreme Court decided to reconsider its decision. So what would be Supreme Court's take with regard to that? I wanted to know your opinion, insights with regard to this.
Shall I respond?
Yes, sir.
A very pertinent and relevant and contextual question. I fully agree with anybody who criticizes that judgment. I don't think that that judgment, all that is decided is in tune with the constitutional fundamentals. It will be reviewed. It has to be reviewed, at least in certain areas of conditions of bail and other areas. I have gone through the judgment. I purposefully avoided mentioning that judgment, about that judgment. There is nothing wrong in discussing that judgment here, because pendency of a review petition is not a bar for discussing it in the academic circles. There should be good discussion also. Your question is relevant, pertinent. I think that that judgment has to be reviewed because it has overstepped. I told you by the course of my discussion, I told there are areas where Supreme Court has overstepped. This is one area where, see, you cannot rule India through ED only. You leave it to others. You listen to others also, what others say. Merely making Supreme Court what you call online or what you call Supreme Court proceedings to be aired. That is, you have to show by your judgments. Madam, your sentiments, I hope your sentiments are with the review petitioners, not with the judgment.
Definitely with the review petition.
Okay.
So there is a question in the chat box.
Please. Sir, is the Supreme Court, is that question?
Yes, sir.
It's a very lengthy question. Okay. Is the Supreme Court doing enough in carrying out the appointments of judges to the Indian higher judiciary in the context of diversity in appointments? I ask this specifically on the backdrop of the government holding back the candidature of Justice Saurabh Kripal, especially when his candidature has been buttressed by the collegium on 2 occasions. How come the government is not carrying out the appointment which is in gross conflict with the settled judgment of SCORA 2016? Once a recommendation made a recommendation is reiterated, made is reiterated. It has to be carried out. How come this bizarre stalemate in continuing? See, if Supreme Court Collegium has a, you have to go by the present law. What is the present law? What is the rule that is in place? If a collegium recommends a name to the government has to process it, law ministry has to process it and place it before the president for signature. If there is any objection, you record the objection, send it back to the court, and if the court again sends it back to the government, there is no other go. Government has to. And this question raised by this scholar in this context here, that requires a positive response. And I don't think that it is correct on the part of the government to make this pocket veto, delaying tactics. But you delay, government has got more power than judiciary. You see, government can play havoc with the people. Your rights and liberties. In 1952, Government of India passed a legislation on a private member's bill. That is right to information of proceedings in the parliament. That is known as Firoz Gandhi Act. Firoz Gandhi was the son-in-law of Jawaharlal Nehru, and he was a perpetual headache also to Jawaharlal Nehru. And Firoz Gandhi wanted the proceedings in the parliament to be published. Jawaharlal Nehru immediately, he was a Chanakya, Nehru. Nehru said that we will pass the legislation. He passed the legislation and put it in the cupboard, did not notify it. Till 1978, it was in Janata Party came in 1978 that this bill was notified, act was notified. See, this is a question of liberty of the people. And denial of appointment to a person after undergoing all necessary formalities, solemnities. That is bad in law. Whether his sexual proclivities, propensities are of a different nature, that is immaterial. I hope I have made myself clear.
So there is one more question.
Sir, Rajshekaran sir.
Yes, please.
Sir, my questions regarding the reforms in judiciary is not sufficient and up to the market, sir, because we spent so many years, but still the justice is denied. The best example is A.G. Perarivalan case, spent 30 years. Then only I come to know that there is an article, such article we have that. So we need those who are all involved in that. Is it possible to punish? Because one innocent is spent so many years and politically is motivated. We come to know that in this case, like that many cases, but not it in picture. And what is your suggestion, sir, to bring? And one more question, sir.
Yes.
We need a time and durations. If suppose I'm flying from Bangalore to Delhi by flight, I need a time of 2 hours or 40 minutes. But where is the time limit or duration I can get the justice from the judiciary? Just keep on postponing, and justice denied and justice delayed. And I need a suggestion for that, sir. Thank you, sir.
Shall I respond?
Yes,
I
sir.
will have a two-pronged response. One regarding Perarivalan's, you have named this case. That is an open and shut case in the Supreme Court. I think what you said is in the either way, if he deserves justice, it must be given without delay. And Perarivalan's case has been debated much in the public than on the benches of the Supreme Court. So I am of the opinion that if Perarivalan he deserves to be freed, he must be freed. But all the merits of the case and all the what you call on the details of the case, I am not making any comments on that. But your sentiments I share, this delay, perpetual delay. And regarding the second aspect of your flight from Bangalore to Delhi reaches in 2 hours, but your flight from injustice to justice reaches nowhere. You will be hovering around over without getting a landing clearance. So that is, I will just tell you in very brief one instance where I appeared as a lawyer. I filed an election, appeared in an election petition appeal before the Supreme Court in 2017 of Kerala Legislative Assembly election of 2016, 5-year term. And the judge, Justice Chalameshwar, said that, Mr. Pillay, we will hear this matter next week itself. I said, I am ready today itself. No issue notice by Dasti. Dasti means you will serve notice by hand. So notice was served and next case was posted in 2017 itself. I went there ready with arguments and all. Then an adjournment. Then further adjournment. Then I mentioned before the Supreme Chief Justice bench that this election petition appeal has to be heard. Then the Supreme Chief Justice said, post it in 2 weeks before the concerned bench. 2 weeks it did not come, 2 months it did not come. I again mentioned before the Chief Justice. Then again, this is the case. Then Corona hit us. Court was on a virtual holiday for 2 years. Even during holidays, during online process, I advised my advocate on record to do it. And in 2021, the term of the assembly is over. 2022, the case is again not listed. When charged with corrupt practices, you want to see a decision from the court, the petitioner. Again mentioned. Then the present Chief Justice, not the present Chief Justice, the Chief Justice who was Chief Justice till yesterday. The Chief Justice Ramana said that, no, you take up this case and post it before the appropriate bench. 2 days back, the case was heard. Then the cry from the opposite side is, this is infructuous. The term is over. I said, no, it is not infructuous because what corrupt practice the candidate did, that remains. Then the court heard it in merit. But you know, the court will have in it, the judges will have in the mind that anyway the period is over. I will hear the matter on merit only to satisfy Dr. Pillay, senior counsel. And then after dictating the judgment, they said that we are in tune with the High Court. So delay. Heard melodies are sweet, but those unheard are sweeter still. That can be used in the negative term. Number of cases are becoming infructuous. Suppose your promotion as a teacher, professor, you are denied. You go to the court and the case is languishing there till your retirement. Then what is the use of this? Justice delayed is justice denied. Justice hurried is justice buried. This is the.
Thank you, sir. There is one more question in the chat box. If you can please address.
Let me see.
Law and
Sir,
order.
how does law and morality converge and the sense of justice can be achieved when what appears to be justice may not be backed by law? I ask this in the context of remission case undergoing in the Supreme Court against the release of convicted rape perpetrators. Would you say by exercising the remission power available under law, a particular government facilitated justice? See, particular cases, particular remission cases, we cannot comment on cases by news coming in the media, first of all. And what is the content of the petition, remission petition file? Sometimes political aspects may come. And recently, I know what is the case that is engaging your attention, remission. Often it gives a wrong message. It gives a wrong message. And in remission, more than in pardon, in remission, you must be very careful. You are again leaving him scot-free or to the society again. I think that there should not be unbridled power for remission. There should be better parameters prescribed by the Supreme Court. Only Supreme Court can do it. Because Parliament doing it is a distant possibility. Okay.
Thank you so much, sir, for patiently answering all our questions. We are actually delighted to have you and for giving such enriching session to all of us. Thank you once again.
So I think we are coming to the close of this session. So it was a good experience for me also. So I wish all of you great success as teachers. Let your students become good researchers, professors, judges, lawyers, and people who are very valuable citizens of the society. Once again, I wish greatness and excellence to this great institution which has invited me for this. I thank our Dean, Dr. Subramania sir, and staff members and all who are associated with it. And given an opportunity, I will come once again to you, even on a physical mode. Anyway, it was a great experience. Once again, I thank you. Thank you, and I will take leave with your permission. Thank you.
Thank you so much.